Namaskar, friends. I hope you're doing well. We will take 10 more questions in this video today from our series to learn a bit more of India's polity. Also, catch the additional and parallel learning through the images on the screen. So, let's take the first question. It says federalism was declared to be a part of the basic structure of the Constitution of India for the first time in which of the following cases? Option A says State of West Bengal versus Union of India. Now, this is the case where the court essentially held that Indian constitution is not strictly federal, as in the states are not absolute sovereign. So we are not like USA basically. So there's no absolute federalism. That's what they said, and that there is a centralizing tendency basically. So this is not the correct answer, but yeah, this is an important case where we learned quasi federalism. Then Keshwananda Bharati versus State of Kerala, very popular. We know this is also not the answer because this is more known for the idea of basic structure of the constitution that the parliament cannot destroy it. Third option says SR Bommai versus Union of India, and that's Mr. SR Bommai in the picture also. It was a 9 judges bench, and in 1989, the Janata Party government led by Mr. Bommai here was dismissed due to defections by some of their party members. And he had filed the case, and I'm sure you know this is a major landmark case regarding the use of Article 356 and President's rule. So it was this case where it was held. That's our correct answer. And also, this is also the same case in which the court held secularism to be a part of basic structure of the constitution. Then the fourth option says Kuldeep Nayyar versus Union of India. Well, this is mainly known for upholding the 2003 amendments to the Representation of People's Act, where open ballot system for Rajya Sabha was introduced. It allowed a candidate to contest for Rajya Sabha from anywhere in India, which earlier was, by the way, restricted to only the state where the candidate is a registered voter. And thirdly, the court clarified that Rajya Sabha elections are part of the electoral process and they are not a legislative proceeding within the House. Therefore, anti-defection law will not apply in these elections of the Rajya Sabha, and MLAs cannot be disqualified for voting against their party's directive. Anyway, the correct answer is SR Bommai. Let's go to the next question. And it says which statements are correct with respect to the fundamental rights. Statement 1 says fundamental rights under the Constitution of India are modeled on the idea under the Constitution of United States. Now this is absolutely correct. It is the Bill of Rights. All of us know, very popular idea. It is the Bill of Rights of 1791. That is the first 10 amendments of the US Constitution on which our idea of fundamental rights is based. That is of constitutional supremacy and certain restraints on the legislature to not let it be tyrannical. Also, know that this Bill of Rights of the USA was essentially called so because of the first Bill of Rights in 1689, introduced in the British Parliament. Second statement says fundamental rights cannot be waived off by the individual in India, but it can be waived in USA. This is also correct. In USA, not all, but many crucial constitutional rights can be intentionally abandoned depending on the circumstances, such as the right against self-incrimination, where the defendant can choose to testify, thereby waiving their Fifth Amendment privilege. Or a person can voluntarily consent to a search of their property, which acts as a waiver of their right to demand a search warrant under the Fourth Amendment. However, our Supreme Court has held that fundamental rights were put in the Constitution not merely for individual benefit, they are a matter of policy. So the doctrine of waiver has no application in case of fundamental rights. A state cannot breach fundamental rights on such basis. Third statement says there is no provision of suspension of fundamental rights under the US Constitution, while the Constitution of India contains such provisions. Now, this is also correct. There is no provision in the US Constitution for suspending rights, whereas we know in our Constitution we have Article 358 and 359 which make such kind of provisions. So all of these three statements are correct statements. Next question is characterizing the presidential form of government. Now, there are three defining principles of presidential form of government, which are the opposite of the parliamentary form of government, simply are that the head of state is a real head and enjoys the executive powers. Secondly, the ministers or the secretaries, as they are known in USA, they are not collectively responsible to the legislature. That is, the head of state is also not responsible to the legislature. They do not have to enjoy majority, and hence there is stability of government. And there is unity of leadership, not collective leadership. Okay, there's just one leader. Then the third principle says that the ministers or the secretaries, they are not allowed to be the members of the legislature. Therefore, there is complete separation of power between the executive and the legislature. Unlike India, where we have incomplete separation of power, where executive emerges from the legislature itself. Therefore, the correct answer is first and second. And that, by the way, the picture is of George Washington, the first president of United States of America. And the next question is giving two statements. First statement says a person who is less than 25 years of age can be appointed as a minister of the union, but for a maximum period of 6 months. Now, a person shall be eligible to become a member for them to be appointed as a minister. So, just because 6 months are allowed, not anybody can be made a minister. The idea is they shall be eligible to be a member. So, a person who is less than 25 years of age is not eligible to be a member of Lok Sabha. So, they can't be appointed as a minister also. So, this statement is not correct. Second statement says a person who is not a member of either house of parliament can be appointed as a minister, but for a maximum period of 6 months. This is correct. This is the basic idea I just told you. And this is also provided under Article 75, Clause 5 of the Constitution. Please have a read. And this picture here is the last of the surviving members of our Constituent Assembly who passed away in 2021, T.M. Kaliannanji. So he was the last person from our Constituent Assembly who survived till 2021, almost 100 years old, I think 101 years old or something. Then, which of the following statements is or are correct? The doctrine of colorable legislation does not involve any question of malafides on the part of the legislature. Now, see, colorable legislation is based on the wider doctrine of what is called the fraud on the constitution. It is a very obvious maxim that what cannot be done directly can also not be done indirectly, right? So when a legislature directly legislates on a topic reserved for another legislature, such a law is ultra vires and void. So if it is done in a covert, indirect, and disguised manner, that is what is colorable legislation, as it pretends to be within its area, but in reality trespasses into another legislature's field. In this test, there is no question of bona fides or malafides on the part of the legislature. It is only a question of competency of the particular legislature, right? So the second statement, it says legislature directly legislates on a topic reserved for another legislature, the law so made is ultra vires. Now this is correct. Both statements are correct. But remember, colorable legislation is about the competence. Are you competent to make that kind of law or not? So both these statements are correct. And moving on to the next question, which of the following statements is or are correct? Questions before the House of Parliament are generally decided by a voice vote unless the opinion of the presiding officer is challenged. And the presiding officer of the House has the discretion to not allow a division while the House decides on a question. Both of these statements are correct. And the general procedure is that the question is put before the House by the presiding officer. And then a call is made for those who are in favor to say aye and those opposing the question to say no. Then the presiding officer announces the result by saying, I think the ayes have it or the noes have it, depending on the situation. Mind it that they say, I think, because they don't know. It is only a voice vote after all, right? So at this moment, members can object and demand for division. Division means the votes will now be recorded. for exact numbers. After the votes have been cast and counted, now the presiding officer announces the final result as the ayes have it or the noes have it, depending on the outcome. Since for most bills where simple majority is required, the status in the House is obvious. Division is not undertaken generally. And you will see the presiding officer announcing the result twice, which is essentially the first announcement of approximation and the second, since there is no objection, like this. I think the ayes have it, the ayes have it. And that's the final result. Anyway, both of these are correct statements. We go to the next question, where it says when the offices of both the chairman and the deputy chairman of Rajya Sabha are vacant, the duties of the office of the chairman are performed by. Now, first observation, only 12% could get it right. And that is what my perception was, and why I thought to make a decently simple question like this. Normally, this skips our attention, though very logical and similar to Lok Sabha. What it tells me is that a large number of us are still struggling with making logical connections and derivations. I hope this question is a reminder for course correction. The provision for Rajya Sabha is exactly the same in the constitution also. It is under Article 91 written there. See, vacancy in both houses and in both the offices of the presiding officer and the deputy presiding officer, it requires the president to appoint one member to preside. It is a rare event in a continuous house like Rajya Sabha. Though it did happen in 1977 when the president Fakhruddin Ali Ahmed, he passed away, and the vice president was Mr. B.D. Jatti, who was then acting president. The deputy chairman post was also vacant, and that was Mr. Murahari, Gode Murahari, who got elected to the Rajya Sabha. Who got elected to the Lok Sabha. So, Mr. B.D. Jatti, in his capacity as acting president, then appointed a member of the House, Mr. Banarsi Das, as the chairman pro tem. Okay, so very similar to Lok Sabha, Rajya Sabha also has the same provision that when both the presiding officer and the deputy presiding officer they become vacant, it is the president who will appoint a pro tem chairman or pro tem speaker, and then they will conduct the election for the next speaker or the chair. So that's a decent derivation you should have been able to make. Anyway, next question. Which of the statements are correct regarding the official languages in India? First statement says the Constitution of India specifies that the form of numerals to be used for official purposes of the Union shall be Devanagari script. Now, this is not correct. This is very clearly provided under Article 343, which I have got here for you. And it says that the form of numerals to be used for official purposes shall be the international form of Indian numerals. And that is also displayed on the screen here. Follow the Indian system of counting, where after the lakh, or how we say lakh, we have Arab, Kharab, Neel, Padma, and Shankh. Anyway, second statement says the Constitution of India does not specify the official language of the states. Now, this is correct, and that is in Article 345. Then, third statement, the President of India may direct a state to officially recognize a language. This is also correct, and this is provided under Article 347. I suggest you read these articles once. Then the next question is regarding the passage of bills in the state legislature. So statement one says a bill that has originated in the legislative council, passed by it and then rejected by the assembly comes to an end. This is absolutely correct. Council is a revisory house only, a secondary house, and not at all like Rajya Sabha. Whatever the assembly decides, that is essentially final. There is also no kind of joint sitting provision in the state legislature. Second statement says a bill that has originated in the assembly, passed by it, and then transmitted to the council can be delayed in its enactment by the council for a maximum period of 6 months. Now, this is where it is incorrect. It is actually just 4 months. And I hope you can recall that it is 3 months in the first instance when the bill comes first time, and the 1 more month when the bill comes to it second time. Do revise this process if you feel confused. So only the first statement is correct, second is wrong. Then the last question for today's video, and it says statements are correct regarding the Constitution 106th Amendment Act 2023. Since this is all over the news recently, and also I hope you know that it was notified only in April 2026. Even though it was made in 2023, it was notified finally just before the closure of the budget session this year. Secondly, it was being talked about in the background of the government's attempt to increase the seats of Lok Sabha by the 131st Constitutional Amendment Act, Constitutional Amendment Bill, which could not become an act. So you may like to read through the entire provision of this Nari Shakti Adhiniyam and be clear with all the provisions. Let's see the options here anyway. It makes the provisions for reservation of seats for women in Lok Sabha and the legislative assemblies of the states. This is correct. And it says as nearly as maybe one third of the total number of seats to be filled by direct election to the respective houses shall be reserved. Absolutely correct. It is only for the direct election seats. That means if they are any nominated seats or like Rajya Sabha and council where it's not direct election, they are not going to be reserved. Only these seats are reserved. And as nearly as possible, one third of the total number of seats reserved for scheduled caste and scheduled tribes shall also be reserved for women. This is also a provision there. All three are correct statements. So that's all for this video. Keep moving forward. Always, Jai Hind.